Welcome to Funnel Reboot, the podcast that shares ideas on how to upgrade your lead generation. Here is your host, Glenn Schmeltzley.
Hey, Glenn here. Thanks very much for joining us for another episode of Funnel Reboot, the show that explores how we can upgrade your lead generation. Quick reminder, this podcast is available on Apple Podcasts or other places where you listen to podcasts. So if you want to get them as soon as they're out, please click on over and subscribe. We had a few recent episodes that delved into some great advanced areas of marketing. One of them was the ability to be human in today's media environment. We had another one on using videos for marketing. I'd encourage you to go check those out. And if you missed them, just go to funnelreboot.com. For today's episode, we want to talk about legal issues, including the not so legal aspects of marketing in a digital world. Those of us who do digital marketing, we don't set out to break laws when we're doing our jobs, but our work pace is pretty fast. And in our haste, we might sometimes take risks that have legal repercussions. There are times also where outside companies have done our brand some harm. And as victims, we want to know what we can do to defend ourselves. Finally, and I'm going to get our guests' input on this, we are doing things that are frankly very new, and the legal framework hasn't quite caught up to what we're doing, so it's not quite clear on whether or not what we're doing is legal. How are we marketers supposed to make sense of all this? Well, what I did is I turned to someone who's highly aware of the ins and outs of business law today. Megan Cornell spent the first decade of her practice working in big law, learning what all businesses in all types of industries need to succeed. But she's always had an affinity for technology, both being used by outside companies and by how the legal industry can use it. And she decided in 2012 to fuse those things to create Momentum, a new kind of business law firm dedicated to providing complete solutions to clients in a way that works for them. Welcome, Megan.
Thank you for that great intro. I am delighted to be talking to the more dynamic industry of marketing in the broadest sense, because as lawyers, we're not exactly seen as the most dynamic and interesting people. When we walk into a room, we immediately know who's in marketing or sales. And it's not the law people.
I get you. That's fine. But we need each other, right?
Absolutely.
We both have specialties that the other frankly needs. So on that note, let's just start by setting some of the things that marketing has on its plate now that it didn't a decade ago, that put it smack dab in the middle of some legal requirements. The biggest one I can think of is how much data marketers hold on to. And this is data that is streaming in through our web analytics, our social channels. And because we have so many systems now, marketing technology is frankly in some companies bigger than the technology department. We're holding on to client data. And Absolutely. It's very sensitive. There's privacy frameworks in place now, new ones coming on in 2020. It's not just Europe anymore. Can you just give us some broad stroke ideas of what we need to think about when it comes to holding on to client data and even data of prospects that we have? What do we have on our hands?
I think that is a great lead in. I'm going to be a lawyer and not answer it exactly immediately by setting the groundwork, which I think is important for anything else we discuss, which is how important all of the sort of risks that we're going to discuss today, how important it is to mitigate those risks by having a written agreement. Regardless of what aspect of the marketing world you're in, whether you're running an agency, whether you're hiring people, whether you're trying to figure out how to support people on your team that are doing this, no matter what, you want to have a written agreement that sets out who's responsible for what. And ideally, from your personal perspective, your company's perspective, make sure that you don't end up liable for something that your client is doing or that the party on the other side, regardless of who they are, you may be the client, what they're responsible for. So, of course, we approach business agreements as business people in terms of what are you providing and how much am I paying for it? Those are the basics. But some of those legal clauses that you tend to gloss over can be extremely important in the marketing world. And we call those indemnification clauses in the legal world. But it's about apportioning risk. So just at a really basic level, if you're hiring a marketing agency, you have them say to you as the client, we are only going to use collateral which we have a legal right to use.
Yep.
So that sounds very legal, but what it can mean is that they're not going to use photos on your website, stock photos that they haven't bought the right license for.
Yep.
And we have many times over many years dealt with clients who have stock photos on their website and they get a letter from, I won't name names, but you know, some of the big companies that have engines out there searching for unlicensed works that are out there, and they're told they owe $10,000 for the unlicensed use of this work. Yep. So that is a really big consequence to a very small thing not being in writing, which is it's not our liability if you do that, marketing agency, it's yours. It's your obligation. So that's, I'm sorry to be so lawyerly, but it is absolutely the starting point, regardless of where you are on this, in this marketing world, to very clearly define who's got the responsibility for what. And like I say, indemnification, which just means you're on the hook for this. We're not on the hook for it. It's your responsibility.
Sure. All right. That's a good starting point. And that put it in writing is something that everybody should have clear in their head. I also know that what you're not saying, because it's going to vary by where the listener is here, what exactly you can just put in writing and it will have legal effect. Right. So to use a similar example, I can't just put a privacy statement on my website that says we have the right to use any information on you any way we like.
Correct.
So the point is to put something in writing. It doesn't mean like that's remember when we were kids and we played tag? That's not a home free card.
No, definitely not.
But the spirit of it, at least, is if you start the process of saying, I have to put something in writing here because I am using something, be it a photo or be it information, I need to go to somebody who knows the law in my area and see what's allowable.
Exactly.
Okay.
And so to your privacy statement's a great example because, as you alluded to, we've got legislation coming at us in every jurisdiction. And if you've got a web presence, which is what we assume if you're listening, you do. Then the fact that someone is in Europe and you're in Canada does not protect you. The European legislation captures anyone anywhere in the world if the user of your site is in Europe. So unless you're going to block people within certain jurisdictions, which of course no businesses in the right mind would do, then you've got to comply with that stuff. California just has new legislation. Canadian legislation is still, in principle, very strong and quite close to the European legislation, which I'll say is GDPR in case I just accidentally reference it that way. And it's not part of your world. You don't know what GDPR is. That's the European data protection and privacy stuff. The Canadian legislation doesn't have a lot of consequences beyond public shaming these days, although there's increasingly some monetary penalties. But you have to know that those things are there. So exactly your point, which is don't put a Band-Aid on it and say, I've got a privacy policy that I downloaded from the internet. I am covered. I'm okay. It actually has to be what you do. So if you say, I collect your data, but I anonymize it and I destroy it after 6 months, you better be doing that. So read what you downloaded from the internet if that's what you do, which obviously we know lots of people do because it can be expensive to get this stuff made for you bespoke. But actually read it, try and find, there's lots of great companies. If you're going to copy someone else's privacy policy, find someone that you know is in the same industry as you, is doing the same sort of stuff as you. Look at their privacy policy. Right. I'm not against you copying them, but read it and understand it and try and find the ones increasingly that are written in real English or whatever language, in plain language, I'll say, that humans can understand. And copy that sort of policy, but then describe what you do and then actually follow through and do it.
Well said. And I'll underline that little part that you said. If you are going to say that you're doing something, do it.
Exactly.
That's great. And there are companies that, have been raked over the coals in things like data breaches. Absolutely. Where they said that they were destroying things and not retaining them. And how is it possible then that some hacker was able to go back 10 years and get all of the information?
Yeah.
It's people try to complexify legal things. That it's quite simple at this little piece of it. Just do what you say you're going to do.
Yeah, exactly.
When it comes to knowing what we have, our assets, marketers probably could use a little bit of a primer on understanding how they can use a name. We love to sit around meeting rooms and maybe after our operations or product people have come up with something, we slap a label on it and say, well, that's a really catchy sounding name. Are we okay to do that, or are there a few other steps we should think of?
So absolutely other steps, not surprisingly. And it sort of depends what you want to do with it and what purpose you're putting it to use. At the very most basic, and I'll talk about our jurisdiction because we're in Ontario in Canada, but whatever jurisdiction you're in, you likely have similar kinds of rules. So if you have a corporation and you're using that name out in the world, in Canada, that's fine. You don't need to do any special registrations. However, what you haven't done yet is protect your name as a trademark. And so in Canada, as in elsewhere in the world, often we think of trademarks as the mark itself, so the image. But actually in Canada, you also need to trademark the name. So there's word marks and there's image marks. So if you're looking through a brand development process with a company, number one, you may be going well beyond their corporate name anyway, and want to look at that trademark protection, which is a whole other registration than their incorporation. And then on top of that, in Ontario, for example, you have to also register it as a business name if you're going to be using it. This provides zero protection of the name from somebody else using it. But from a commercial point of view, you need to have registered it if you're operating out in the world as that sort of business. And the reason for that is completely different from the trademark protection, which is the public needs to know who they're dealing with. So if your name is ABC123 Inc., but you're holding yourself out as best marketing agency in the world as your business name, you need to register best marketing agency in the world so that people can search that in the business name registrations and see, oh, it's actually this corporation. So there's a whole bunch of different things to think about when you're thinking about the actual name for the business.
Right.
Take that a step further, which is, of course, the marketing world, and we get into things like tags, taglines, and as we said, the image, which might change over time as you work on your brand. And some of those things you can trademark as well and stop the rest of the world from using it in relation to your good or service. And that's really key. A great example we'll give is Momentum, because Momentum Business Law, we have a trademark. Nobody else in the legal world in Canada can use the word momentum in relation to a law firm or online legal services or anything like this. We've protected it. We are now in the process of opening a co-working space, as you know, and we now have to go and register a new trademark in relation to, I don't know what the category is, whether it's rentals or I don't think they're sophisticated enough to have thought of co-working as a new category. But to be, Momentum Spaces, we now want to register Momentum in relation to this new venture that we have. So you have to think you're protecting yourself in a little narrow category. And then, of course, if you're looking beyond your own jurisdiction, Canada, US is a common registration that you do both. We know there's law firm in the US that has a trademarked name of Momentum, so we can't register there.
Sure.
So that, to your point, to circle way back, because this is what lawyers do, is a really important step to take initially is to look at where am I going with my product? Where do I plan to be geographically with my product or good or service? And is my name going to translate elsewhere? Can I protect it elsewhere? Because you may come up with the most amazing name, do a bunch of Googling, which is our common first step in investigating whether we can use this name for what we want to use it for. And not stumble upon the fact that somebody in Europe is using the same business name for a similar sort of venture. And then, be stopped at a certain point in your business development plan down the road because Europe was always on your radar and you hadn't done the right searches.
That's great. And as marketers, like you said, we don't have to stampede towards a legal resource. A few minutes of getting on a search engine might help us. And I think there are a lot of marketers, especially in technology, take a SaaS company, where this is going to happen sooner than they think. Mm-hmm. It's not necessarily, well, we have to have bricks and mortar locations in each one of these. We may be already crossing borders. Absolutely. And from a legal standpoint, that matters. You are all of a sudden into looking at that jurisdiction and seeing if you're actually doing it right.
Yeah, and from a business perspective, the world has gotten really small. We think of a global marketplace really, really quickly. You can as a solopreneur service a global marketplace currently, but law is still 100% jurisdictional. There is no such thing as one worldwide trademark registration. It does not exist. Every single country needs to be registered in. Yeah. And in some countries, multiple jurisdictions. For the most part, that's a kind of national level registration, but it can't be ignored depending what your plan is.
And of course, advertising transcends this too. If I'm even putting ads in another jurisdiction because I might want to treat it as a target market, I've got to consider whether I've got the legal footing to do that. There are things, as we look at things like advertising, where it can be dicey. There can be times where we can either see our own name being abused or where we can maybe be making claims in an ad. Can you just give us the broad strokes of, are ads considered something that you can be held legally responsible for? What do you have to consider when it comes to putting something in an ad and balancing that desire that you have to entice someone's interests with the fact that there might be a need for truth in advertising, and at least
truth
for
in advertising.
Hey, crazy idea, for the people who are seeing it, that they can hold you to account for what you're putting in there.
Yeah. Again, unfortunately, highly jurisdictional.
Okay.
So if you are pushing ads into a certain jurisdiction and you're at all concerned about this topic area, sadly, you should at least spend a little time on Google researching that jurisdiction. Generally speaking, there's two concerns: Consumer Protection Act and Competition Act. Competition Act, it's easy to think of it as this act that applies to giant companies that are, is one company allowed to buy out another one, or is this going to cause a retraction of service in the marketplace that's not good for consumers? But it actually can apply on a very, very small business level as well. And it constrains on exactly the point that you raised, truth in advertising effectively. But it can also restrain things like comparisons, we're the number one, whatever. If you're going to make a claim, it needs to come from somewhere. So a really common thing, and I'm sure that, the competition police aren't out watching this, but you might see a restaurant that advertises, we were voted number one and blah, blah, blah. Well, you better be able to show whatever that survey was. You were the number one hamburger in Ottawa, and have you attached a year to it? As I'm sure that makes the marketing world just cry, because it's like lawyering up the claims that you want to make. And as with all things legal, understand the obligation, but then apply a business lens to it. So if you are a pizza joint or a burger joint, how likely are you to be called to task on whether you've met all the criteria of the Competition Act in your marketing? On the other hand, if you are a big global company and you're making claims that just aren't true, you are much more likely to be called to task. So, but understanding the obligations, because if you're, for example, an agency or even in-house, you don't want some complaint to be made. And most of this stuff is complaint driven. Yep. So it would be your competition likely that would complain. And rarely is it sort of initiated by whatever governing body, because they just don't have the resources to be out watching internet ads, to be honest. So understand what those obligations are. And then you can risk identify, and you can say to whoever your client is, whether you're internal and it's the market, you're talking to a team, or whether you're an external agent, or whether you're the consumer and you want to ask the question to the supplier. You may still decide to go forward with whatever the wording is because you like it and you're comfortable with it, and you've identified that this might be slightly in the gray zone, but I can live with that risk because we've determined that this is the best route forward. But at least you've identified the risk, and if you're the agency, you've passed it to the client to say, we all agree we like this wording.
Yep.
Got to be honest with you. It maybe is over here in the gray zone on this front. Can you live with that? And the business people will decide, but at least you've raised it. You've, back to the lawyer wanting to apportion the risk appropriately.
Yep.
It's way better to identify the risk than get a complaint letter and, all hell breaks loose then with your credibility. So
yes,
you don't want that.
Right. Just do it up front. I love what you said about the business lens. I hear this at least from you, not from every lawyer, but there's clearly a desire to align what you need to do for your business with what's legally proper. And I guess a simple case there is if you're looking at a claim like we're the number one burger joint, and that information actually is already on, let's say, a review site, the internet is flat. You could easily, and from a business lens standpoint, it would probably be better for you to just point people to that and say, there's third-party information.
Yeah.
We didn't make this up.
Yeah.
And the credibility will be greater there. A way that is getting used nowadays has an interesting twist on it, and this is when it comes to influencers. So they're also third-party people, but there's a big difference between them and, let's say, just the masses who have gone on and given a review.
Yeah.
Influencers are paid.
Yeah.
Tell me what your take on how, if we're going to engage influencers, what we need to be aware of.
So, not surprisingly, I'm going to say get it in writing.
Sure. So this is your agreement with them?
To do. Absolutely. If you're engaging them, it should be in writing. And ideally not just email. Have a template. If they don't have one, they should have one.
Yep.
And we have a form of influencer agreement that we provide. But ask to see their agreement. If they don't have one, that's your first tip off that maybe they're not super professional. These things don't have to be 25 pages long. You can have a one-pager agreement, but you want to know exactly what you're getting from them. And you also very, very, very importantly, when you're hiring them, want to be able to terminate it and require them to remove all mentions of your product, basically completely erase the fact that they have ever dealt with your product or endorsed it if they do something which you are no longer comfortable associating with your brand. You've hopefully done your research about the influencer and you've seen, a sort of string of content from them that you're very comfortable with how they affiliate with your brand, etc. But that doesn't mean that that's always going to be the case. It's an incredibly powerful tool. And I frankly embrace it. I think it's wonderful that this sort of democratization of brand voice has come around. I think it's great. But it's also the Wild West.
Yeah.
And the last thing you want is somebody who posts content on their personal feed, even if they have kind of different feeds, right? That you no longer want affiliated. They endorse something that it blows up all over the place and you have heavily featured your product with them. So you want to make sure, number one, that you own any content that they create, that you can take that and repurpose it and use it if you're paying them for it. They may push back on that and you may negotiate that point. But also you want to make sure that you have absolute ability to terminate the contract under whatever financial terms, again, that you're going to negotiate with them on that, but that you can force a complete removal of your brand from their brand effectively. So that's, again, I think it's a hugely powerful tool. I don't think you should run away from it at all if it's appropriate for your brand, but make sure you're well protected in terms of your ability to shut that down as well as own the content that they're creating for you.
Sure. And you've connected a few more dots for me. There are guidelines that are just good practice in general with social media. And I'm sure most people listening to this, if they look inside their company, they probably have a set of guidelines for internal people to use if they're, even if it's well-meaning, if they want to help promote the company.
Yeah.
These are the do's and don'ts.
Yeah.
Should also be applied to an influencer.
Yeah, exactly. I mean, consider if you want to engage with someone that's going to ever post personal political commentary. That's a big one, right? Is that it can, and sometimes people post stuff with very few filters in their own mind. And ideally, again, this person has a long track record that you can see, okay, they don't go off on a pro Donald Trump or pro whatever side of the field you're on some of these hot button political issues right now, and instantly alienate a whole audience for you. I mean, it's not a day goes by that we don't see something in the media or advertising world where something like this is blowing up, right? Yeah. And it's great because it connects us and it personalizes business, and it's all those things that are important to selling a product or a service. But it just also increases your risk because you're not just reading a static magazine ad anymore, although there was lots of stupid mistakes in that world. Right.
But there were usually some eyes on it, as you said. Somebody can be on their phone and in a moment do something that you can't undo.
Exactly.
I appreciate how you're saying there are many ways that we need to be looking at getting out and finding ways to get to our audiences. It's been a topic on our podcast that in general, mass advertising and mass public relations aren't necessarily the way anymore. Privacy frameworks are getting so that people can block out stuff, and it's, causing us to look in areas like influencers where if we don't know what we're doing, we can take a misstep. But the truth is, those first-party audiences, the ones they have and that we have, these are where it's becoming most valuable to our company to go and reach people directly. So I kind of want to finish on that aspect because one of the areas that we all have inside of our companies is an email list. Mm-hmm. And that is something that we consider to be very near and dear. And we mostly want to do well-meaning things, but yet again, in our haste to want to sell or to make, this quarter's or this month's numbers, we sometimes can do things that will be against what we should. What are the do's and don'ts of email when we're looking both if we're sending, let's say, single messages as well as messages en masse?
Mm-hmm. Great question, particularly because I've just been playing around with MailChimp, where we use MailChimp internally, and not a newsletter goes out that my eyeballs aren't on. So I've been deep in the weeds of a particular new marketing campaign this week. So great question, great timing. So my first answer, number one, use a platform. Do not be cutting and pasting. And it is shocking the number of things you see that still come to you this way. Whether you have an Excel spreadsheet or whatever you're doing, make sure you are using a third party. It is not expensive in the grand scheme of things. And they provide you with a whole lot of frameworks that meet the legal requirements that are so important to comply with right now. The biggest one being the unsubscribe button. Unsubscribe must be available under pretty much every anybody that has some sort of email marketing legislation in Canada. It's called CASL, C-A-S-L. And it's incredibly important to meet those general requirements. And the unsubscribe is the baseline. Like somebody has to be able to say, I'm irritated, I received this, click unsubscribe, and it be easy. If you have to go create an account on your website just to enable an unsubscribe, you're in big trouble. And that's the sort of thing that gets a complaint because people get irritated very easily about these things. You'll still see things come in, or I will still see things come in from international jurisdictions, particularly where there's no unsubscribe. And boy, is that irritating. I mean, yes, I can junk filter it very quickly, and most email programs start doing that for you eventually. But as a baseline, do that. And most MailChimp and others will block you from re-adding that person if they have unsubscribed, which is really, really valuable.
It's for your own protection.
Yeah, exactly. Because you might, if you've got an extensive list, you might inadvertently try to re-add that person. So that's really important. Use a third-party provider, and it prompts you through various things to do, ensures that there's the required information in terms of who's sending the email and that sort of thing. So it's kind of a shortcut to legal compliance. Yes. And you're far better off. If you're just going to type, please reply to this email if you don't want to receive anything further. Well, it's possible that meets the legal requirements, but just go get one of these third-party providers. I'm not paid by MailChimp.
No, fair enough. Yep.
So that's number one. Number two is where the contact comes from, which is really, really important, right? And in
like,
Canada,
where did you get that email?
Yes, exactly. So in Canada, CASL gives a really easy breakdown on these points. And you have either express consent or implied consent before you can send a message.
Okay.
Express consent is obviously I checked a box on your website saying, please add me to your mailing list. Great. Express consent is given, and that lasts forever until it's revoked with the unsubscribe button.
Yes.
Implied consent can come from a number of other routes, and it can be, it's short-lived. In Canada, it lives for 2 years. So you then need to have a system where you've recorded where that contact came from, how you added them, when you added them, so that they will fall off the list. Is that being done? Like, probably not at all, right? But if the person has continued to get your email list and hasn't yet reported you, to the authorities for sending an unsolicited email, chances are they're not going to. And so I think that timeline around the implied consent is the one that's probably failing the most. And we may see some kind of governing, legislative eyeballs on that eventually, but I don't think it's a huge thing to be concerned about. One thing that maybe not everyone understands is that if you publish your email on the internet, you have given implied consent to anybody to email you. So if you have a system set up where you're scrubbing emails in a particular industry or something like that, you are giving your implied consent to the world to email you. So before you get furious about someone sending you an unsolicited email, ask yourself, is my, on my professional page, is my email there? And if it is, your only recourse is that unsubscribe button. The other thing that gives implied consent is giving someone your business card. So basically providing your contact information.
Yes.
If that is done in one way or another, you're fine. You have implied consent. What is not okay is buying a list that you don't know where it comes from and you don't know what consent was given when that list was compiled. So buying a list from anywhere is really risky behavior, and it's the sort of thing that is likely to end in a complaint, particularly as consumers get more aware of and more flooded, frankly, with spam emails, that they're most likely to complain. So on the emailing, that's key. That's broad strokes. The legislation goes a lot deeper. There's now penalties, etc. Don't get caught in them. It's the last thing you want to get. And I'm sure you are constantly talking about high quality contacts. It's better to have, 100 high quality contacts than 10,000 complete garbage contacts anyway.
I can't disagree. It's, again, this idea of a business lens that goes in the exact same direction as the legal. The non-legal test, I would say, is, would somebody be surprised to receive an email from you about this? And, that's usually not a good thing, right? So if they have had some interaction before and it wouldn't come as a big surprise that there would be an email from you. Even that 2-year, there are very easy systems for culling a list and looking at the decay and looking at, okay, here's somebody I've emailed every month for 2 years. They haven't opened or clicked through on a single one of them. Yeah. From a business standpoint, why would I want to keep them on my list?
Yeah, exactly. Yeah. And sorry, clients, anyone you have a business relationship with also falls under implied consent. You're totally fine if you have an ongoing business relationship and for 2 years from the end of that business relationship. Okay. So again, culling your list, seeing what's stale, seeing who doesn't want your content anymore. If you're your existing client, we have an interesting point where we have third parties that support our clients, and they go into our database because they have access to various pieces. So we can communicate with them because we have had a business relationship with them, even though they're not directly our client. But, we still have an unsubscribe button if they don't find our newsletter that we direct specifically to content we think they would find useful. If they don't want it anymore, they can unsubscribe, and then they're gone from our list, and we won't accidentally add them again because our system would flag that and say, well, you don't want to add this person.
That's a great point. And it creeps up on marketers in surprising ways. Most marketers who've ever done a webinar, and there are two parties on the webinar, that's exactly the situation you just described. Maybe not described in that same way, but they are all of a sudden involved with sending things to another audience who they didn't have direct express consent from.
Exactly.
So they need to start looking and seeing if they're applying those same tests that you did.
And that's actually a really great point. If you are going to do that sort of content, ask the people that you're doing it with. Say, can you add a consent for anybody that's gone to this webinar that I'm...
Great.
I mean, you're giving your time to these people and you know that they're developing their list from it. So just ask them to add, add in the information where when you sign up, you're agreeing to receive communications from us and the service provider blank who's going to be on the webinar with us. If they haven't done that, then technically you don't have consent, and their offer to share the list with you is like a double-edged sword.
Yeah. Back to the surprise component, perhaps even staying above the legal bar, but looking at it from the person who signed up for it. You've at least twigged in their mind, okay, I might be getting something in the future from this party.
Yeah.
And
exactly.
I don't know a marketer out there who wouldn't at least like to get that impression across to that party, and it might get them thinking in a new way. Megan, it's been great to get these things from you. Any kind of hot legal areas that we haven't touched on that are on the horizon?
Definitely the one I think I briefly mentioned at the beginning in terms of the written agreement, but always make sure that you have an understanding of the content that's being created. Number one, where it's coming from, if it's original content, who has the right to it, whichever side of the fence you're on. If you're on the agency side, do you want to be able to repurpose this for another client at some point? Like that has to be in writing. Who owns the content? Whether it's technically intellectual property or not, you want to make sure that there's a really clear understanding about that. If you're using stock images or any third-party content like that, completely understanding where it's coming from and who has the liability if it's done wrong. That is something that I think is really, really important in your field, and it's shocking to me how often it still comes up because there's great sites out there, right? But so if you've bought a license for something, if you're on the side where you're providing the content and you pay for a license for the product that you're going to use for your client, you better keep that license. Like make sure you have a copy of when you downloaded the asset, attached to it the license. If there's a timeline on the license, if there's rules about what you can do with the license, throw it in a folder.
Sure.
So that if a question comes up, you can easily point to it and it shows that you're on top of that issue, and it helps your credibility in a big way.
Awesome. That's very helpful. And these are only like a few minutes here or there that it takes, but it can save a lot of headache later. So we finish always with a reboot where we're encouraging people who want to solve the commonest of problems with this and at least give them pointers on where they would go and look. So in the legal sphere, where would you suggest people who want to at least teach themselves enough to know what they don't know?
Yeah.
You mentioned two kind of key pieces of law that are out there, and can you just maybe tell us where people would go to find out about them?
Yeah, absolutely. Wherever you are in the world, look up, just Google to see if there's any kind of consumer protection rules or legislation or body that governs that, and then competition as well, particularly competition if you're crafting the marketing messages. So you understand if there's rules and guidelines around what you can't say. And then one step further, if you're dealing with a particular industry and it's regulated, for example, lawyers have rules about what we can say in our marketing.
Yep.
So if this is your first lawyer that you're doing work for, our law society has rules about what we are allowed to say in advertising. We're not allowed to compare to other lawyers, for example. So we can't use the word best or anything, or jurisdiction where we are. So whatever jurisdiction you're in, do a quick look for those consumer protection, competition, and then if you're dealing with an industry that you think might have regulation around it, do a bit of a dive there because your client may know about it. And again, you don't want to embarrass yourself that you haven't thought through something in a whole marketing pitch that you put forward to them.
Sweet. And you said that this isn't like there are websites clearly that each one of these legislative bodies put out, but you've said that you can even go farther than that some of them go to the bother of making this information really accessible.
Yeah, Facebook, the Consumer Protection Agency in Ontario has really great Facebook presence, actually. They're fantastic. I follow them on Facebook, and I'm always impressed with the messaging that they put out around various pieces that are usually hot button pieces, but that can lead you down into, more targeted content that you need for sure.
Sure. So even if we're a little shy of wading into a website of laws, nobody's going to shy away from at least spending a bit of time on Facebook.
Yeah, exactly.
Megan, this has been great. Where can people get a hold of you if they want to reach out to you?
Momentum.law is where you find us, and we're always happy to chat.
Terrific. Thanks so much for your time.
Great, thank you.
Thanks for listening. Follow the show on Twitter @Funnel Reboot. If you like what you have heard today, please consider leaving a review wherever you get your podcasts.